Welcome to the 5-Minute Legal Master Series, where expert attorneys help you master important legal topics. Today, board-certified creditors' rights and business bankruptcy attorney Robert S. Bernstein discusses execution.
I thought we'd talk today about execution, which is the process of enforcing a money judgment. Execution may come by different names in various states, but generally speaking, an order of execution comes from the court, tells the sheriff or the marshal or some other judicial officer to seize property of the defendant to pay the judgment. We've talked in other sessions about post-judgment discovery, which is a way of finding out what the defendant owns that might be subject to execution. Once you know, then you can issue directions to the sheriff and have the sheriff levy on and sell the property. Now, there are different procedures depending upon whether it's personal property or real property. And personal property meaning not something necessarily personal, but it means non-real estate. In a personal property execution, one can have the sheriff go seize a car, a truck, equipment, inventory, things that the defendant owns. The sheriff will then make a list, publish that list in one way or another, have a sale maybe 2 or 3 weeks later or 30 days later, depending upon the locale, and there would be bidding at which time the property would be sold, and the proceeds would then be distributed by the sheriff to the judgment creditor in payment of the judgment. There can also be attachment of assets in the hands of another person, most usually attachment or garnishment of a bank account. When a defendant has money in a bank account, that is actually a debt that the bank owes to the defendant. In a garnishment proceeding, you can garnish that debt. And if you follow it through, you can get the bank then to pay you the money as the judgment creditor of their depositor. The bank may have set-off rights if the bank is owed money, so you have to be careful there, but at least it usually has a way of getting your defendant's attention because it immediately locks down the bank account. When there is a going business, when there's a store, the sheriff can do what's called in some jurisdictions a till tap, essentially taking the money out of the cash register as it comes in. In some states, that is at the discretion of the sheriff and the plaintiff. There's obviously an extra cost involved, so you have to be aware of that. With real estate, it's a little more complicated process. There are usually more notices, formal advertising. Notices have to go to lien holders. Each jurisdiction is different in the ability to eliminate or get rid of other liens on the property. Generally speaking, an execution is going to sell the property subject to any liens that were created before the execution, but not liens that were created after, or liens that were subject to liens that were created before the judgment, not necessarily after. After the sale, the sheriff will propose a distribution. The sheriff may propose to certain lien holders. There's an opportunity to object to that. There's also an opportunity for the defendant or for somebody other than the defendant to object, saying, the defendant doesn't own that property, I do. You may see that when you try to execute on a judgment against an individual. If that individual is married and these are home assets, furniture, things like that, there may be a claim by the spouse saying that he or she is a joint owner in that property. The goal of execution is take the asset, turn it into money, and then distribute it according to whatever statutory priority to the creditors, hopefully the executing creditor, the judgment creditor that has caused this execution.
This has been another installment of the 5-Minute Legal Master series, where expert attorneys help you master important legal topics. For more information on this and other topics, please visit 5minutelegalmaster.com.